conflict and look to promote the profession of conflict resolvers. We are available to connect with at greggf@primus.ca and also at fentenmediation@gmail.com. That's fentonmediation@gmail.com. And also, you can connect at 647-227-4734. Visit us at our Facebook page to like us and Facebook group page to become a member. You can also visit YouTube and watch past shows at Fenton Mediation. Listen to podcasts of Mediation Station on SoundCloud, Apple Podcasts, and on Google Podcasts. Please follow us at our Twitter account, which is at Fenton Mediation. Our topic for conversation today is called What's Law Got to Do with It? And with me will be, and very shortly, is Ben Drory. So we're connecting and continuing to do so each week on Sunday night as usual from 8 to 9 p.m. Eastern Standard Time through Zoom because of COVID-19 restrictions that the radio station must adhere to. And this will go on for the next interim period. I don't know when. Life is always changing currently. So we'll engage in conversation with everyone attending, able to listen in and watch the conversation. Microphones and webcams will be closed. And if anyone wants to contribute anything, there are two options. One is to see the chat icon as a bubble at the bottom center of your screen for you to click to then type in a comment or question and click to send. Or you can click the reactions icon also located in the bottom center of the screen, and you can click the hand icon, and such as what's being displayed now. And we'll notice that, and we'll open up your mic only for you to share through the audio, your comment or question, and then we'll engage with that as part of the conversation. The show is being recorded for both video and audio purposes, and that'll be uploaded, as I mentioned, to Fenton Mediation channel on YouTube for the video. And actually update everything, all the past 6 shows, I believe, are uploaded there now. I haven't gotten to editing all the audio versions, so that's still to be done. So let's navigate and shift to the conversation for tonight. And with me is Ben Drory, and what's law got to do with it? So hi, Ben. Welcome to the program.
Hey, Greg. How are you doing? Pleasure to be here.
Yes. Thank you for being here. And as you mentioned earlier, off air or camera, This is the third time you've been on with me in less than a year, though it's also the third form of approach that we've been able to do it through.
Yeah, it's been a new challenge every time, but it's fine. It keeps it exciting.
Yeah, you called in the first time, the second time you came to the station, and now we're Zooming it.
I think you're out of other options.
Yeah, no, beam me up, Scotty. I don't know if that'll happen, though. So for the benefit of people, how about you share some information about your professional background?
Certainly. So I work as, it's a pretty diverse mix of things I do, but I work as a mediator, also as an adjudicator with a couple of tribunals around the Toronto area. I used to work with the Third. I also do a fair bit of investigation work in the ombuds sector with banking and municipalities, also workplaces. And I also do coaching and mediation. That's one place where also we're aligned. We also do some coaching together at one of the local universities. It's work I enjoy a lot. I like doing a lot of different work related to mediation, in addition to mediation itself. So with mediation, I've actually done insurance mediation, but I've also done a lot of community mediation as well with a couple of local agencies, including with your Downsview agency back in the day.
Yeah, that's how we first met.
That's right.
And I know someone in the crowd, I won't out her. She also was a mediator volunteer with Conflict Mediation Services of Downsview. We were located on 95 Eddystone up in the Jane and Finch community. And yeah, we've had connection, cross paths over the years. And most recently, for the last few years, you've been involved as well as me with a certain university located in North Toronto
That's
and
right.
coaching. Yeah. So what's your experience with people when they have a conflict in a generic way or general way?
Usually, like my experience is they're not very good at addressing it. They're not very good at handling it. They don't, every individual is different, but the average person is not very skilled at sort of managing conflict. It's just not something that you're taught in school. That's not something that you tend to be actively involved in developing as a skill as you grow up, as you grow older, as you move through life. So what tends to happen is a lot of resentment gets kept, and you have some people who are very, very explosive, very expository about what it is that really is bothering them. You have others who do the total opposite. They just bottle up and won't say what's bothering them. Obviously, neither of them is very effective in terms of getting things done. Like the way that you need to get things done is by coming out directly, addressing the issue, having a discussion about it. But that's most of the time not what people do. So there is in almost every case I'm involved in a fair bit of work, fair bit of education that has to be done just to get people comfortable with even having a conversation at all, because it's not something people tend to enjoy doing as a default.
Yeah, I mean, traditionally people see conflict when they hear that word, it tends to be perceived and understood and processed through a negative lens.
Mm-hmm.
It's something bad or difficult. And I think you share a similar perspective that conflict can actually be a great opportunity for growth and development, positive change too.
Yeah, tremendously. I try to do that just in my regular life, seeing, conflict in and of itself, like, can be, and in my opinion should be, like an opportunity. I'm not saying it's always a positive thing that you're involved in it per se, the actual act of it, but it creates an opportunity. It means that there's something there that either one or both of you need to address, should be addressed. Take the time to actually come out and address it, and that's going to be more effective than avoiding it.
Yeah, when we say the word opportunity in connection with conflict, it's like an add-on value. It's something that builds upon something that's currently happening and maybe that people are not happy with, they're struggling with, and then with the opportunity, it's seen as a potential that can bring positivity in some way or hope with regard to the situation for people.
Mm-hmm. Because I certainly know, like, I know several people who, like, their default reaction would just be to avoid it, not say anything, bottle it up, and that you can't expect anything positive to come from that if that's your reaction, just by not doing anything about it, letting it continue. All you're going to usually get is the same thing is going to continue to happen.
I don't know if you remember from, earlier days in the training, and we had the animal motifs with regard to personalities and characteristics. And when you talk about people hiding, it's the turtle. They put their head inside the shell and they hope it goes away when they stick their head out again.
Mm-hmm. That's right. I haven't heard those motifs in so long, but yeah, that's absolutely it. And it's an ineffective approach to conflict, but as are many others, like people who are explosive and angry, that's also ineffective. And you have to work, part of mediation and conflict resolution in general is dealing with these different kinds of personalities, and you will approach them each differently, but there's basically a way that you should try to approach conflict, and you're trying to, all these other personality types, try to move them towards that.
So what was the impetus, or what was the piece that really presented for you to transition to include mediation as part of your professional practice? Because I know you've got a legal background.
Mm-hmm.
You did go to law school.
I did. Yep.
Yeah.
Yes.
So what
And
was
yeah. Go ahead. Continue.
Just what was your thinking? What created within you the light bulb moment to say, okay, how about I try mediation?
I can't remember what it was, the light bulb moment that got me into the course, but I remember the course that we now teach or coach together. I was a student in that course around probably about 15 years ago now, and just when I did it, like, that was when it happened, was when you start realizing, like, how engaging it was, and just like you feel, I felt like a genuine connection to doing this kind of work that I hadn't had like doing legal related work before. Like I had done a variety of things in the legal industry or tangentially to it. None of them. When I got into law school, I always thought like part of the goal was, okay, get in there, make a difference, do something good for society, like help people out. And what I found when I got out of law school and into the working world is it just the kind of work that was being done wasn't that. And it's sort of left, you know, you would get paid for it obviously, but it wasn't fulfilling in a sense that of what I was hoping for, what the original point of going to law school was. And honestly, for a lot of people who were also there, I knew as well. I just found like working in mediation, like that was a chance to directly help people. That was a chance to really engage with what's bothering you here. What do you really want to get out of this interaction that it's not happening? And I just felt like an instant connection to it. It's like, this is a genuine way you can really help people out and make a difference in the world, which was part of what I was always looking to do all along.
So my deeper question is, why didn't you continue on the pathway with law, the legalistic perspective? What wasn't happening for you there?
It was partly opportunity. I think a lot of it, honestly, just like my personality didn't really mesh with a lot of what the legal industry tends to value in terms of like how they would deal with clients, how they would deal with each other. I find it just, one thing I've learned over time is like fit is such a big thing in any employment context. And I just found I've gotten better at it over the years, but I just found that certainly back, if you go back 20 years, and I think I've grown a lot in that time, but probably back 20 years ago, I wasn't like a good fit for that industry, and it wasn't a good fit for me. And I thought the mediation industry, such as it is, was significantly better aligned with my values, aligned with my personality as well. How I could harness the talents that I had in a way that it would utilize them in a good way and effective way. Whereas just as a lawyer, I would have just been like pretty average. I think the field I'm in now, I'm really just quite a bit better at. So that was a part of it. But passion is so big in anything you do in the work world, and I was able to just there's a much more genuine passion for what I'm doing when I'm working in mediation or it's related, or the related fields, that working in what I was doing before, it wasn't really there.
And I would think with the passion, there's a deeper intention to participate, to contribute,
Mm-hmm.
and it provides a greater depth of, sense of, a connection with it, and you get more
Mm-hmm.
out of it per se.
Oh, absolutely. And I whenever I'm talking with anybody just about employment in general, like you need to be getting something out of the work that you're doing, and if you're not, why are you there? Like it's not something that you're likely to be around for long, because if it's something you're doing day in, day out, you need to be enjoying it, you need to be driven to be working in that kind of field.
Yeah, I mean, so many of us, have an idea, we're going to go for school for this, get an education,
Mm-hmm.
get trained this way, and then get some work experience. And many of us do that because, well, one, we have to make a living,
Mm-hmm.
and we have to find a way to generate revenue so that we can pay our bills. And I think it's just an added level of connection when you can do what you're passionate about and simultaneously make a living.
Yeah, it's amazing. Like what I've just the last few years have probably been among the best years of my career, just because of that, the opportunity to like do stuff that I really enjoy, and there is like legitimate remuneration there. Like it's worked on both ends, so it's something I'm like very happy about because it satisfies both of those objectives.
Yeah, I know many people struggle because there are jobs doing things that really they have no real interest in other than generating income. And when they show up, it's like work. And I always found that when I went to CMSD, that it wasn't work for me. It was opportunity with creating a space and means for other people. So it was my passion. I went to, quote, that space on Eddystone because I wanted to, not because per se I had to. And I see the difference, the distinction. work as I have to, and passion as I want to.
Absolutely. And you could, looking back like to that era, like you could always tell, like just like the engagement of the people who were part of that organization was higher than other similar organizations I've been with since then. Like it was something that really stood out about CMSD was the passion and the engagement, not just of you, but of everybody else that was a part of that group. And certainly, like I've worked with some other community organizations since then, but they haven't had the level of engagement or even so among the members, I would say that there was back when I was with the CMSD group. That was something that really stood out about that group to me.
Well, I really appreciated, for myself being able to be part of that and to create opportunity not only for myself, but for other people as well, such as yourself.
Yeah, that's where it began.
Yeah. So as we know, there are a variety of ways to do mediation and in a number of areas of practice. How do you define your mediation approach?
It's interesting because my style, it's really hard to define. It's really a hybrid of a lot of different philosophies that are out there. I think a lot of people will tend to define themselves as a facilitated mediator or as an evaluative mediator or transformative. I think if anybody was to sit and actually watch what I do, it's not really any of those particularly. It's really a mix of a lot of those different philosophies. And I really move around, and if in a given case you have to be facilitative, you do it. If you need to be evaluative, you do it. If I had to define what I do, it's really a somewhat analytical. I do a lot of work in the case development, really sit down with the folks that are involved, like really understand, okay, tell me a lot about what happened. What do you feel about it? And try to understand from what are the facts. Then I'll speak with the other side, do the same thing. And then I'll try to really have a sense, even before the mediation itself starts, of, okay, what are the facts probably here? Because each side's going to be telling me their story through a different filter. But there's probably certain facts that if they're both talking about it, that's probably a genuine thing that happened, and they're just interpreting it in different ways. And then I think, okay, if that's the issue here, and I know how they both feel about it, I know what they both have told me they want to get out of it. I do a lot of analysis before I even start. Okay, where are the different directions this might go? What are the things that, okay, if the conversation goes in this direction, I know from what one of the parties has told me that's just not going to work at all, or it's really going to upset them. And I really try to navigate and steer the conversation in directions I think are going to be positive and lead to results for at least one of the parties, hopefully for both of them, partly because through the opportunity to learn what both parties think from the case developments, I have a pretty good idea from the start of what might work. And I'm not there telling the parties this is what you should do, but I'm really trying to sort of massage and manage the nature of the conversation towards directions that I think are going to be positive. If I think one party is going somewhere that's going to be really negative, I may let it happen, but I'll try to sort of dissuade them, or I might interject or just warn the party what might be coming. It's really just trying to manage the personalities, manage what I think the reactions are going to be. So it's somewhat conflict analysis, I think, is really a lot of what I do. And then based on what I hear from the parties, okay, I will like be pretty flexible in how I do my approach. My approach is not the same from case to case. It's really context specific. So, for example, if I'm working in a community case, I'm gonna, my engagement wise, be a lot more involved than, for example, if I'm in an insurance case where you've got lawyers there, they do this day in, day out. This is just part of their job. They're in regularly. If I'm dealing with them, I'll just tell them, okay, let's go. You know how this works. Let's go. So it's really context specific to how I know the parties are going to react, like in how I engage with certain parties, how I engage with lawyers. It really is just based on a judgment of who do I think these people are that I'm talking with, and what's going to be effective in communicating with them specifically. Because if you try the same thing with some people, with one person, it's going to be different with how another one does.
So, comment from the crowd. Do you see a difference in the cases who have lawyers versus those who do not have lawyers?
very much. It's something like we talk about in class occasionally when we're doing them. And I know among different coaches, there's actually different perceptions about whether having the lawyers present or not makes it easier or harder. For me personally, I find having the lawyers actually makes it significantly easier. And the reason I say that is, so we were talking a bit earlier about there's a certain way to approach conflict that can be more helpful, and how do you want to direct the parties to be having their conversations. And you sort of want to be getting the parties eventually to a place where you're talking, instead of talking in very highly charged emotional ways, really charged about like, you did this, you did that, or I'm never going to speak to you again, or these are the threats. You want to eventually get them to a point where they're talking rationally, talking logically, talking about what are the facts here, what are your options going forward, what do I want to see achieved here, versus are there ways I could potentially address what you're looking for. And I find the lawyers, when they come in, because they're not personally involved, they're there doing the job. Like they don't come in with the same kind of emotional attachment to the case that the parties have. And they also, by the nature of just what they do automatically, like lawyers, their whole job is about, one is about advocacy, but the other part is about analysis and rationality. And they sort of come in with us, thinking more about the conflict in rational terms, in terms of, this is what the law says, this is what my client is entitled to, this is why you're not entitled to it. Let's talk about it. I just find it, for me, it's actually an easier conversation to have, because it's so much less emotional to begin with. Now the problem you have when you do that is, if there's real emotional aspects to the case that should be addressed, then you have to make more effort to bring that in. I do enjoy doing that. I do enjoy, if I see there's emotional aspects of the case that should be addressed, I will try to directly invite it in, even when the lawyers don't want to go there. But I do find like the actual, like the nature of the conversation is a lot different with the lawyers present. It tends to be more analytical and rational, which for me, I find easier. But I know for some others, they find it harder. So it's really based on an individual approach, whether that's better for your personality or not.
Yeah, well, I mean, it can be that if there's a lawyer in the room, the sense is, let's not go to the emotion. Let's remove the emotion. Let's not even bother tapping into the emotion. And I know that we know that many people's lived experiences are from them being affected from those experiences, and they create feelings from those, and many times they're not of the best experience. No. And so when they come together in a mediation process and they want to chat about, and we try to open up that they get to share their own perspectives rather than, per se, I use terminology perspective rather than fact, because fact to me delineates truth or right or wrong. And when we have people coming into a process, perspective is somewhat non-judgmental. It's your point of view relative to another person's point of view. And it's not saying my point of view is better than yours, because fact for me implies it's, quote, the right fact relative to your facts, which are the wrong facts. Though that's the positional approach. When you have two competing perspectives, how do you have facts on one side that are, quote, the truth relative to facts on the other side that are, quote, the truth, because that's a recreation of the court system.
Yeah, I mean, everybody has their own opinion about what facts, what took place or what didn't. It's quite possible that one is right and the other is completely out to lunch. I mean, that happens. That actually does happen very often. Like my goal is really, when I do think a lot of times it is relevant to talk, like it's inescapable actually talk about, okay, what actually happened? Like get the perspectives out there. You can't address the case without having a discussion about what, from your perspective, what happened here. Like my opinion is, like, a lot of times, actually almost all the time, you can't move forward into the future with a resolution until you actually address and come to some sort of understanding about what it is that happened that led you here in the first place. There needs to be a discussion about what actually happened here. People are entitled to different perspectives about what it was that happened, but I do
Right.
think you need to have a discussion about what
Yeah,
was
and if you just
and
get
what took
people
place.
together and start to say, oh, okay, what do you want to do about it, without really going below the surface and
Mhm.
putting some pressure on the situation, rather than like the symbolism of an iceberg staying on the surface. You got to probe and pull it out from below the surface of people's lived experiences, their fears, their concerns, their wants, their
Mhm.
desires, etc. And that's a lot of connection with feelings. And so we have to talk about, from my perspective, my experience, and my approach,
Yeah.
talk about the past in some way.
Yes.
And because we're now here in the present talking about the past, and the intention is to create decisions that are based on future actions.
Yeah. And I don't mind like having like a case be somewhat of an attempt to figure out what the facts were, be somewhat of an attempt at finding the truth. There usually won't be an agreement, okay, where both sides are going to agree, yes, that's what happened. But I think what like in the actual world, there was an event and there was an actual fact of the matter. I mean, we don't know what it, as a mediator, we don't
Or
know
something
what it
happened and
is.
it happened a certain way, right?
Yeah, like something did happen, so it's worth having the discussion. It's worth trying to like make an attempt to figure out what it was. I find even the law, like the legal system, like the law itself is a dispute resolution system. It's just been around for a lot longer and developed over more years. But the purpose of the law is really a dispute resolution system that the state endorses, that makes an attempt at least to try to figure out what the facts were in its own way.
So, the justice system is an advocacy of positions against each other,
Mhm.
and that's the third person in the room. The judge is the adjudicator, the decision maker.
Mhm.
And the template with mediation is, even though there's lawyers in the room, there's individuals who are directly living or lived experiences, and then there's a third person. There's that mediator. The mediator is totally absent of their intention to make the decisions on behalf of the parties, which is a totally different paradigm from the court process.
Mhm.
So, what do you see? What's your experience regarding the roles of lawyers and mediators, or a mediator and a lawyer when they're in a process?
I find them complementary. I think that there are some who think that that they can't work together and they're trying to do totally different things. I find the roles really complementary, and I think the parties who are involved are well served by both a mediator and a lawyer being there. Like the reason a party would hire a lawyer for themselves is to the extent that they have legal interests that could be protected or that they want to be protected, they're going to hire the expert in that role to help them do that. Like the average person doesn't know the law, certainly isn't used to working within the legal system. If you can hire a lawyer to represent you and put you in help put you in a better light, either for the judge or for the opposing party, that makes a lot of sense to hire somebody to do that. But the mediator is there. The lawyers are focused on, okay, what are you entitled to as a very narrow question. What are you entitled to under the law? The law doesn't protect every interest that's out there. The law protects what the statutes and legislation say is a protected interest. Mediation can go much broader. It protects just what we call in mediation training just interests quite generally, which is what do you want to achieve? Like if you could have anything in the world in this case, what is it you want to see here in terms of how this person is approaching you, or the things that they're doing that are impacting you? What do you want to see here? Because the law won't necessarily protect all those things that you want. You can have a discussion in mediation. You can have a discussion about those things that if you take it to court, the judge can't do anything about it because it's not even something the law protects.
Well, the concept of self-determination,
Mhm.
where if you go into the court system, a justice system, it's a rights-based approach, as you've mentioned. It says,
Right.
okay, so this situation's happened. We have to try to validate or identify through, quote, evidence or facts,
Mhm.
what's, quote, the right one relative to, quote, the wrong perspective or position, and then an outcome is created by the judge, the adjudicator, and imposed on the parties.
Yeah.
Whereas, in mediation, we talk about the interests, as you said. What do you see? How do the worlds of mediation and law intersect? How do they cross paths?
Very well. So as I just mentioned, like law is actually like a dispute resolution process
Yeah.
in its own right. It just works in a very specific and formalized kind of way, and it protects certain interests and won't protect others. Mediation is about really trying to broaden the scope of what you're doing here. It's really trying to look at not just narrowly what the law has said will be protected, but looking at what do you want here? What's the real problem that happened between these parties, and is there a better way of addressing it? And when I say better way of addressing it, this is something I learned, I guess, more in recent years when I became an adjudicator. One of the other things I did, but so many cases that come before you, like as an adjudicator, which is like a judge type function, you end up saying, like, there's so many cases you end up saying, this doesn't belong here. Like the parties raised this case before this tribunal, or however I got appointed. And I'll just say this issue doesn't belong here, and there's nothing we can do about it. And this is something that has to be addressed privately between the parties, because this is outside the jurisdiction of this tribunal. They raise all these 8 different issues. Only this one specific issue is one that we can address. The parties have to privately resolve the other 7. Mediation is where you resolve the other 7. Mediation is where you talk about everything that's not within that narrow little box of what the law protects, where you can talk about everything else that's in the relationship between the parties that is bothering them. And I've learned over time that as an adjudicator, you can get so bothered by the parties having all these problems between themselves, and as an adjudicator, you can only deal with like one of them, and there's 9 of them that you can't. And you just want, sort of because I have the mediation background, you almost want to shake them and say, I really need to send you to a mediator here, because that's what you really need. That's what you really need more so in this problem, is to, between yourselves, address all of these problems between you that the law doesn't care about, but you do. And there needs to be a way to address that in a better way, just through communication between yourselves.
Yeah, well, if I'm hearing right, you talked about the jurisdiction, that
Yeah.
the law has a particular intention. It deals with this area of concern,
Yeah.
and other matters that are outside of that you have to deal with in another process. Though the power that mediation can be, that people can deal with all those other issues that are not, quote, part of the jurisdiction of the law, in addition to dealing with the areas that are part of the jurisdiction of the law, because people do have the power to determine for themselves and work together to negotiate what the outcomes will be.
Yeah, you could address all that as well. It's entirely appropriate to have that discussion. Say, okay, if we go ahead and litigate this at the tribunal or wherever you are, what do you think is going to happen here? That's sort of, that addresses part of the way you can use the law and the mediation is, what's your when you're talking about your best alternative to a negotiated agreement, part of that is, okay, not just the cost of going to court, but if you go to court or whatever the equivalent is, what do you think is going to happen there? And you can have that discussion about what you think might happen there. And that's entirely appropriate. And somebody might have a better case than the other, but that's a reasonable thing to have as part of the discussion.
So you and I had a coincidence that we actually, we're connections on LinkedIn, and I saw something and you sent me something in support of our conversation for tonight, which I'd already connected with, and I sent you further. So it was a posting by a guy named Jeff Sharp, and apparently he's an international mediator. And his posting, I'll read it. The role law plays in mediation fascinates me. I often hear lawyers apologizing for spending time on the law in opening presentations, because we have been taught it's all about interests, not positions, and certainly not legal ones, right? Well, no. Parties' substantive legal entitlements affect settlement outcomes because a strong case can demand more as a condition of agreeing to a private settlement than can a weaker case. substantive legal entitlements affect bargaining power and thus very much influence outcomes. So he refers to this law professor in terms of something. He wrote a paper in 2004, and his name is Russell Korobkin, and the role of law in settlement. When he says the law creates, shapes, and constrains the ability to exercise bargaining power in mediation, which in turn affects both the likelihood that disputes will settle out of court and the terms of settlements. The best mediation advocates in simple English directed at the decision makers will say something like, here's how we see it. We have some soft spots, but overall we'll do okay if we have to go there, and here's why. In private, those decisions makers will quiz their own lawyers to sufficiently understand the other side's case and reality test their own. So that was something that was his posting. What really brought more attention to me is the response comment. Another mediator I follow on LinkedIn, Greg Rooney, who's from Australia. And he wrote back, not sure I agree, Jeff. The best phrase for me is that mediation takes place in the shadow of the law. The law is definitely there and legal representation is important, but it is only part of the equation. Mediation involves humans, and as such is inherently complex. The human equation is as important as the law to secure the best outcome. Mediators must engage with both to allow the best solution to emerge. Then he goes on with a little more commentary, and then mediation opens the door for the messy mess and unpredictability of us complex human beings. It is out of this messiness that a direction emerges that will shape the eventual outcome. It is often unexpected and something that can't be predicted just looking through the legal prism before the mediation starts. So there were a number of other comments afterwards, further on. Most of those were in support of Jeff and the legal perspective, the legalistic view that mediation has. What's your sense of this?
Yeah, I saw that as well. Like just there was just such a mix of different opinions saying like they liked one opinion versus the others.
Yeah.
There were some that said that they agreed with both and they thought the two sides can work in harmony. I agree with that. To me there's not necessarily a contradiction between the two. Like those are things that can work in harmony, and part of the reason I say that, so when I would work in insurance cases, you would see one more like, you would see mediations more like the original post, where the mediations, even though you had someone who was like badly hurt in an accident, had a lot of things they want to say, them, the mediations tend to be, you have two lawyers present for each side, and you would talk about this is what's going to happen. If this goes to the next stage, goes to arbitration, and we litigate this is what's going to happen here. This is all the reasons I'm going to win, you're going to lose. And that was about 90% of the discussion. In community cases, you're not always even necessarily dealing with a legal issue. You would have very little or sometimes none of that at all. It's all about talk about the relationships between the parties and talk about like what really matters here. Is part of why when I'm doing like coaching, I always tell people, context is really king. Who are the parties that you're working with? What are the sort of the expectations they have coming in for what the process is? And certainly, like, if you're dealing in a case within a tribunal setting where you're in the mediation stage, if you don't settle the case, there's an automatic adjudication stage just there set up for you afterwards. It's very easy and legitimate to have a more legalistic based argument, because that is your BATNA. That is, if you don't get this case settled here today, that's where you're going, is litigation. Let's talk a bit about what's going to happen if you go there. You can certainly have the relationship discussion, but it makes sense to have that discussion there. But if you're having a discussion between neighbors or family members, the law, like, it doesn't matter as much. It could be relevant in the sense of, okay, if you actually somehow took this to court, what would happen? But it doesn't fit as well. It wouldn't fit nearly as well. And really what you're trying to solve is the relationship component. So it's really I don't think there's a a disharmony, so to speak. I think it's really contextual. And it sort of gets to what I was talking about, like right at the beginning today, that you're really looking, a lot of it is about conflict analysis and thinking about what are you here to do today? What is the thing that you can do today for these parties that will really help move this matter forward? Sometimes it's how, if you're in a tribunal setting, it could be more about talking about the legal issues. That's what you're there for. But in a family case, you're going to be, the whole point is the relationship. That's what you're there to fix. That's what I want to try to help today. It's going to be more oriented to that type of discussion.
Ideally, yes. Though if you go to family courts, you'll find they're busy. And many people end up streaming into them for a variety of reasons. And they give up ownership of their, quote, family matter, their relationship matter with the other parent. That's really a lot of times about the interests of the children. My interest is this parent, and relative to the other parent's interest for the same child or children. And so people, it's so dysfunctional from my experience, having been firsthand experiencing what the front lines of family court is in the system, that it just doesn't address the true nature of the lived experiences of people for decision making.
Yeah, and I will say, like, I think the natural inclination of people is they actually want somebody else to make a decision. I think that's partly why the law became so entrenched in the first place, is because people instinctively, they want to do that rather than what we were talking about earlier, rather than making the effort to engage a discussion. Like, engaging a discussion with the other person you're in conflict with, honestly, is emotionally, it's a harder thing for most people to do. So even though we know that there's a much greater opportunity there to fix the problem, a lot of people will be resistant to it. So that's a lot of times what you have to address early in the mediation stage, or even to get them to the mediation in the first place, is convince them, look, this is really in your best interest to do this. Here's all the reasons why, because you have the chance to personally resolve an issue instead of leaving it to somebody else. The reason they're willing to go to somebody else in the first place, I just find people, there's a tendency to just automatically be comfortable with the idea of letting a third person decide. There's just, whether it's a social conditioning, or I think it could just be like an automatic human condition as well. Just say that there's a certain comfort with just, I have a problem with this person, let's let somebody else decide it.
What about what we talked about earlier about the the animal trait? We talked about the avoidance of the turtle.
Yeah.
A lot of people avoid conflict because they perceive it and process it as a negative, and so they go the other way, or they hide themselves within, and they put a sense that, hey, I can't deal with this, hoping that someone else will come in and rescue them and fix it for them, or that things will clarify and resolve on their own.
Yeah, I think I wonder if sometimes, like just us, like talking about like the mediation industry as a whole, sometimes we just have to understand more just how hard this is, like the process of engaging for people. Like, it's something that we do as day in, day out. Like, we're sort of used to engaging conflict. We enjoy doing it. Like I said, we have a passion for it.
Yeah.
There's so many people who don't have that and are literally afraid of it, that it's sometimes I think we have to empathize more with the people who just like, it's just like an automatic reaction to want to run away from it. And maybe just have to be a little bit easy, like we as an industry have to be a bit easier with them, and just understand that it's actually probably, they're more common than we are, honestly. Like people who don't like it are more common than people like us who do like it. And I think understanding it's a bit of a sell job to get them to want to actively engage the problem.
Yeah. I mean, we have to be self-aware, that people will not process the same moments as each other, per se. And then if you get somebody who's trained as a third person, like a mediator facilitator, they have to put themselves somewhat in the shoes of the person who's expressing the concern and the issues of negative conflict with regard to someone else, and how do they navigate with that So we have to use, as you mentioned, about the empathy to appreciate and understand where they're at, to where ideally they want to be, though they don't know how to get there or what to do to get there. So what would you inform people about regarding having them have the ability to make their own decisions that mediation provides for?
I really want to get them focusing and thinking about the positive opportunities. Like a lot of times, their natural instinct will be think of risk. Like you're going to make me. You're like I see it so many times. Like you're going to actually make me talk to this person. I can't speak.
Yeah.
This person's crazy. They're nuts, or they're just. You can't trust them at all. Like that's so many times the automatic instinctual reaction.
Yeah.
And it's so much. I try to, as much as possible, first calm them down a little bit. Like say, I can tell this is difficult for you. This has been a real problem for you. I see that. I just want to have a discussion about like, here's all the reasons you might want to try to address this matter yourselves. And here's all the reasons it might be a constructive thing because you have to continue dealing with this person down the road. Part of that is establishing a stronger relationship with them now. You can actually work to develop the relationship with them now. Whereas if you try to like litigate this, you're just throwing gas on the fire. You're making it worse and worse. You're just making it more positional, more formalized. And try to get them to see that that's what's happening. That by continuing to do this, it's actually making the situation worse. Even if they somehow won in court, they're not really solving their long-term problem. Their long-term problem is a relationship with this other person. The way to improve that relationship is to actively engage it and trying to have like a rational discussion with them to sort of get them to see that. A lot of times it takes a fair bit of time to get them off of their just natural hesitancy more towards a point where they're like, yeah, I see what you're saying. Yes, I think that would be positive. I agree that would be a good thing to do.
Yeah, in civil matters or business matters, that people have a connection, a relationship, and then they go to, they have an issue that impacts that relationship in a negative way, and then they have to try to make decisions to address the issues amongst them. Relative to family, because you have an added value type of relationship. You have the intimate relationship and you have a parenting relationship. And when the intimate relationship ends, transitions to become separates, you still have a continuum of a connection ongoing as co-parents. So trying to create a positive template, as you just talked about, where people can actually still work together and collaborate, even though they've separated and become independent as human beings from that intimate relationship, that can be really challenging.
Yeah, and you're certainly not going to get that through litigation because litigation, as I was talking about jurisdiction before, like litigation is not designed to address that. That's not the intention of it. And like I would imagine any judge is going to actively try to get away from that because they're going to think this isn't what I'm here to do. That's for the parties to address among themselves because that's what should appropriately be done.
So why has there been this, from my experience, recurring situation where mediation is more seen as a legalistic relative to a relational process? Going back to Jeff Sharp, he sees it through a lens of the law, legalistic, relative to others of us, even though I've been well experienced in the justice system through criminal with private information court and family and small claims court.
Yeah, I think a lot of like a few things. A lot of it depends on the context people work in. I think certainly like among like, for example, the lawyers and adjusters I would deal with all the time back in the insurance field, they would think the entire like 95% of this is about the law. They would know just as a de facto day in, day out, you're having discussions about what are your legal entitlements under the insurance regulations. we know this person's been hurt, but like we deal with so many thousands of these cases, it's not that big a deal to us. We're just analyzing the case based on their injuries, the nature of the accident, and it's just a very simple, like unemotional discussion to us. So for people who are involved in that kind of work day in, day out, yeah, you're going to see it as a legalistic thing. I think part of it also is the nature of the way mediation is trained. I think we were talking right at the beginning, there's a lot of different philosophies of mediation in terms of examples being transformative mediation, facilitative mediation, evaluative, things of that nature, and interest-based mediation. And some of them are just descriptive. They just say, this is what mediation is. This is this is the role of the parties. This is the role of the mediator. This is what happens in the process. It's a description of what takes place. But some of the theories of mediation are much more normative. So, for example, transformative mediation, in its purest sense, specifically says there is a almost like a correct way to do mediation, a purpose that you're there to do. It's about directly about strengthening the relationship between the parties and generating a certain understanding in both directions of what each party is bringing to the table. And it specifically says that if you don't do it that way, then you're wrong. You've actually done it wrong. You haven't respected the process the way it's designed. So there are some mediation processes that inherently are more normative than others, and say that it's not just a description of what happens. It's like, this is the correct way to do a mediation.
So for me, it's always been a struggle in some way that when people use the term, this is what mediation is or should be,
Yeah.
I have a challenge with that, because I believe I try to take as open-minded a sense of what it is. And it's more like, this is what mediation could be, depending on the situation with the people involved.
I agree with you. Like I really try to like craft an approach that I think is going to be understood and work well with these specific parties. Like really analyze what's happened here. How can I be of the most value as a mediator? And certainly, whenever I'm doing coaching, I go to lengths to actually tell people, look, there are certain things that you must do as a mediator in terms of whether you have like an ethical responsibility or professional responsibility in terms of, for example, making sure they're informed about the process. Make sure you explain the process to them in the beginning. There's certain things that you must do, but beyond that, like everything else is really a matter of sort of the art of how you conduct the mediation. It's really personal to your own style and using your own strengths in a way that's really like going to like engage the parties, build some sort of connection and a rapport with both parties, make sure that they trust you, get them talking with each other. I find a lot of times like the less I say, the better, because the whole point of the mediation process is to get them talking among themselves. Like if I'm doing most of the talking, that's usually a sign that it's not going well. The sign of a good mediation is that they're talking to each other. Even if they're not agreeing, they're having a discussion, they're having a conversation that's still better than what they've been doing before they came in here.
Yeah, if we're working harder than the individuals, participants, it's a cue that it's actually, well, one, like you said, they're not necessarily actively involved, and two, that maybe you're taking too much ownership of your participation in the process. And I believe it's more to be supportive and complementary to what's needed in the moments.
I agree. We have discussions about this in the field all the time about how much you be trying to get an agreement. And I genuinely believe that getting an agreement isn't automatically the purpose. The purpose is the discussion. Like I know as a practical matter, like people will tend to judge you a bit, like, do you come to agreements or not? But I find that if you do the mediation the right way, if you do the right things, engage parties in a positive way, in a respectful way, the agreements will come from it. Like if you run a strong and effective mediation, like more like you put yourself in a good position to get agreements. But if you actually go in with an approach trying to get an agreement, that's when you don't get one. The purpose of the mediation is to generate discussion, generate collaboration, try to build some understanding, and agreements a lot of times just come from that process of getting that understanding. But the value of mediation is from generating the discussion. That is our job.
Yeah, and so, I use the word adaptability. I think we have to be connected to our moments to then say what's happening to what's not happening, and then what do we need to do in order to try to make something else happen that will be ideal, i.e. such as, Mike showing up here, and there's a comment in the crowd that Mike needs to talk to someone. Well, I don't know if this is the space for Mike. I will, though, put it out to you. We're going to close out very soon. Anybody want to throw, in a gentle way, other than the manner of Mike, anything come to mind, comments, questions for us to navigate with from the people in the crowd? Hello.
I've got the happy birthday thing on from before. Sorry.
Look who's here. Do you know her? Do you know her, Ben?
We do.
Yeah. Ben and I also met at York. Sorry. I was at a birthday Zoom and I forgot to change my background. I like what you were saying about how some of the different styles of mediation sort of have a format written in stone. And I didn't really get feedback as to whether you think that's appropriate or not. I love the fact that we're allowed to pull from each of those different styles what'll work in our own setting, in our own situation. That was one thing I wanted to comment on. I just wondered how you felt about that. And then can I bring the second one up then, and then I'll change my background so I'm not saying happy birthday. The other thing was when you said there was a discussion about how's law and mediation intersecting.
Yeah.
I think that's actually happening a lot more now. There's a situation I was just called to mediate where the judge did the big chunk and actually sent them off to mediation to do the rest and said he wouldn't deal with it, which I've never had that before. But I thought that was really kind of interesting. And I think that's sort of starting to happen more than it used to. I don't know if it ever happened before, actually.
I do think
on that.
Like my sense in general is judges and adjudicators, I think, have certainly over time become more familiar with mediation and want to direct more things to mediation, because like there's so many issues that I get when I'm working as an adjudicator in tribunals that come before us. They're making 9 complaints. We can't deal with most of them because this isn't the appropriate forum to do that. And if you know that, you can get the sense that you would be much better off mediating. I commend the judges for doing that, because they're taking ownership and saying this is the appropriate way to address that. I think it works much better. That gets to something that gets talked about in the adjudication field a bit, about active adjudication and sort of like what's the appropriate role of an adjudicator, like how interventionist do you become. But certainly the trend there over time is to become more active, sort of become more European style, where you're going to take more authority and not just leave it to the parties to give you the arguments, and if they don't give it to you, you're stuck. There's much more of a trend there over the years to say, as the neutral deciding the case, if something is inappropriate has come up, you should actively do something to address that. And I totally endorse that. Just to get to your first point, I mentioned at the start that my own style is very much a hybrid of a lot of different philosophies and theories that are out there. And I think I personally like really pick and choose like from a variety of different theories, because I think each of them has something good to say. Like none of them, I haven't encountered any mediation theory that I think is completely inappropriate, but I do agree with Greg that to the extent that a mediation theory says this is what mediation should be or must be, I completely disagree with that. I think there's so many ways that you could approach mediation. I think so much of it is about creativity and being responsive to the parties in front of you. And you just say that there's only one right way to do it, I think is, for one, is factually wrong, but also I think limits the mediator in a way that really detracts from the process, because so much of the mediation process is the creativity of the mediator. I think that really plays into the success of the process.
I really agree with that, because there's some that are so rigid that they insist on even the seating arrangement be predetermined. And I understand where that comes from and how they're figuring that into the whole process, but it doesn't always work. And I think as mediators, the beauty of our job is that we can be flexible and deal with things as they come up, as we've seen tonight, in a way that's going to work best for the people at the table, not the way that it's going to work best or fit into a pigeonhole. I guess that's
right. Yeah, I just really try to be flexible analyze what's going to work well for these particular parties, and what's going to work well in one case is I know just would not work well in some other cases, so I do something different in those, and I have to be able to do that.
So I would call this what I'm hearing the theory of hybrid mediation, whatever that means.
It's my own.
It's taking different perspectives, points of view. You know, when I started at CMSD too, I had the first two cases with the same person. We work under a co-mediation model, as you guys know, and the experienced mediator is your mentor, and me as a newbie. And going into with this first two cases with this person, I just felt that those cases were the worst cases. I felt very bad because I thought the outcomes could have been better for the parties. I was taking too much ownership for it. And I learned soon that to be able to separate myself from the parties and at the same time be connected to the parties. It's a duality of simultaneous experience. So one is that you're hearing the parties through the act of listening, and then you're understanding your role is distinct, not to take ownership of their decision making, though you're also creating a connection through the empathy and the compassionate. So you're trying to help support them in whatever way works. And I turned those negatives into opportunities from my own point of view. And that's what I took into my role at CMSD and further on, that it's not about me, it's about the parties. And trying to help create the conditions for each person in each situation, even in the same situation, the two parties or more are processing their moments different from each other. And that's been part of their struggle. So our purpose is to create a template of conditions that works for these two people in this situation relative to the next. We open up a new door and we adapt to that one too. So that's what I can say to you, Ms. Lynn.
And as Roger Fisher says, separate the parties from the people from the problem. So what you're saying is exactly that. We're connecting with the people, and that's where our connection is, but we're not assuming responsibility for or ownership of the problem. That stays in their realm.
And that goes with the concept of self-determination.
Yeah.
That when people can better connect with their lived experiences and have the control and ownership as much as possible to create those outcomes, there's a greater probability that they'll agree to them in the process and then even further on follow through with them afterwards. And that's ideally what you want to do. You want to create a template at the process, at the table, that will sustain itself as a legacy further on. So I want to be respectful. We're going into overtime.
Yeah.
Anybody, thank you, Lynn, for your questions and comments. Anybody else in the crowd want to contribute anything? All right. So anything in closing, Ben? What's next for you?
Just to show up and do some work tomorrow. Actually, today, like March 14th, is the anniversary of the last time I went anywhere in person to work. We were actually at York, so it's every March 14th we're together doing these things like this. It's good.
Yeah, last year we were doing our thing coaching at York, and we were doing it in person, and then COVID hit, and all of a sudden there was a pause put on the program and the coaching, and then within a week or so we transitioned to doing it online through Zoom. And life has been
that was a great challenge, and life is still there.
Yeah. So thank you very much. Appreciate the opportunity to share and build upon. And
pleasure.
We have to take one moment at a time, right? And deal with the unexpected. I don't know if we'll keep Mike in for tonight's video or not. I'll have to have a conversation with the editor.
Yeah. He's banned.
I don't know. I wonder where it would have gone if that was actually him or not, because there was a person being shown. And usually I think when people Zoom bomb, they got somebody else, not themselves. I don't know. So thanks very much. Have a good night, everyone. And we'll see you next week. All right.
Thanks, everyone.
Thank you. Bye-bye. Yeah. You can sign off. Yeah.